This list represents interested and affected parties.
Indeed, Milady.
So what is the point that the applicant is making at the moment?
So the point I'm making is it provides us with another list of people in respect of which we can do the same exercise and contrast this list with the list in at the beginning of the First Nations report.
The applicant never referred to any irregularity with regard to the public participation process insofar as it relates to First Nation groups. Why are the applicants relying on documents emanating from other sources?
Lady, I accept that that's the best that I can do in terms of identifying people who weren't consulted.
Yes.
But there are other aspects of the process that we say are non-compliant with paragraph E, which render the report non-compliant with that paragraph. And that's where I'd only read the first paragraph of Mr. Jenkins' affidavit in that regard.
Is my understanding correct that that there are no indications in the founding paper, in the founding papers with regard to lack of public participation of any group belonging to the First Nation?
We can only determine exclusion through inference.
Yeah.
But the complaints then continue on page 732, milady. Mr. Jenkins says, our concerns were vindicated when we saw Mr. Orance's report entitled River Club First Nations Report, which purports to be an investigation of the aspirations for the site on the part of the First Nations people, the UFMAS report. And then 56, he says that when he sees the report, his concerns were vindicated. And it's worth remembering that his starting point was a concern about conflict of interest on the part of Mr. Orance, and that has a resonance with the submissions that were made by the amicus, when he said generally that the process should be run by the state, or at least checked by the state. And so while one's initial reaction to his sensing a conflict might be one of doubt, seen in the light of what we learned about the requirements of international law in relation to consultation, that has validity. One can see why they're concerned that the state should be the party that is overseeing the process. So in paragraph 57, the UFMAS report, and he lists his complaints, downplays and obfuscates the significance of the area and its associated intangible heritage to the Gurungai Kona and other indigenous people, seeks to delegitimize the view of the Gurungai Kona Khoikhoi Indigenous Council, seeks to undermine the standing of the chief of Gurungai Kona and to portray the Gurungai Kona as lacking credibility to speak about the significance of the area, elevates the First Nations collective as the authoritative voice of First Nations peoples in relation to the proposed development, and seeks to portray proposed development as a victory for the First Nation peoples. The UFMAS report includes WhatsApp screenshots to portray the chief of Gurungai Kona as unreliable or unstable. To my knowledge, no attempts were made by the author of the report to get the chief's comments, to verify such screenshots, or to place any such comments in context. The UFMAS report also quoted parts of my previous interview by Mr. Orance without acknowledging me as the source, and despite my having made it clear at the time of the interview that it was not to be used in support of the proposed development. The report characterizes the Gurungai Kona as drifters and outcasts and presents extracts from the diaries of Jan van Riebeeck that describe the Gurungai Kona as this ugly Hottentot race, a gang who are lazy and never set hand to work until you have promised to give them a good quantity of tobacco or food or drink. They live by begging, stealing and robbing. In contrast, the Gurungai, the group currently in support of the proposed development, are presented as the traditional custodians of the historic landscape that encompassed the River Club site and the broader Two Rivers area. The use of these extracts from colonialist diaries, which are replete with racist assumptions and prejudice, is clearly to attack and undermine the Gurungai Kona in our opposition to the proposed development. The UFMAS report also uses examples from other First Nations groups around the world and posits them as precedent that can be applied to the River Club site. This implicitly but misleadingly positions other First Nations groups as having been aligned with the proposed development. And with respect, that goes to the heart of what a proper consultation process backed by international law should involve. The trust element is completely missing. The treatment of everybody as like or equal is missing. The good faith element is missing. The goal to reach agreement with not just one group, but with all groups is missing.
I cannot see any indication from all the paragraphs that you have read. The court is still in the dark as to which groups were excluded and which were not.
I accept, my lady, I've stated what the best case is that we can make as far as that is concerned, but the submission I make is these are additional considerations pleaded in the founding affidavit that in interpreting paragraph E would have to be taken into account if your ladyship was going to comply with the obligation that with respect rests on the court in terms of section 39 1B, I think it is, which obliges the court to take into account international law in the interpretation of paragraph E. And that wouldn't just involve consulting with everybody. It would involve a number of the other elements that Mr. Bishop referred to in his argument. And those cross swords, as it were, with some of these complaints. And with respect, the complaints here, if one looks at the report, yes, they're not exclusion complaints, they're different complaints. But there are certainly complaints that could have resulted in exclusion. And even if your ladyship is not convinced as far as that is concerned, in terms of meaningful engagement and the fact that it has to be interpreted with reference to judgments about meaningful consultation, like the Scalabrino judgment about what has to take place in a consultation, these complaints we submit would successfully knock out that as being a compliant process. That's the submission we make that we make in relation to that. Not just the exclusion. We say, yes, we have a case that is not ideally pleaded in relation to exclusion. In relation to the other complaints, we say, yes, the case is ideally pleaded. Your ladyship's attention wasn't drawn to it by my learned friend when going through these. And it's in the founding affidavit, lady. So those would be the submissions in relation to paragraph E. If I can then come back to where I was going to start. But I want to start by dealing with the OCA judgment under the rubric prima facie right. First respondent argues that the prospects of success in the review should play little, if any, role, and that this is really a case about the other elements of the test for an interim intellect. And I think that view is shared by other respondents too. The main case for that proposition is OCA, where it says the prima facie right a claimant must establish is not merely the right to approach a court in order to review an administrative action. It is a right to which, if not protected by an interdict, irreparable harm would ensue. One can see exactly why in that case that had to be said. If one goes on to read what the threatened harm was, that's at paragraphs 53 and 54 of the judgment. The respondent's case was based on financial harm to motorists and persons in the transport industry. There was no constitutional right that was being threatened. That is why the court said that the element of impending irreparable harm was wanting, and a reasonable prospect of success on review was not good enough. We say that OCA is distinguishable in two respects. From the applicant side, they are not fighting about money. They are fighting for their right to their intangible heritage, and importantly described as living heritage in the statute. the respondents are all at pains in these proceedings at this stage to say that they recognize fully the intangible heritage resources that reside in the site in its entirety. First respondent itself acknowledges, in their heads of argument, that it is an associative cultural landscape, and I emphasize the word landscape. And I also emphasize the word associative. The word associative correctly conveys that the intangible heritage is inextricably linked to the land and the landscape. Paragraph 105 of their heads of argument, they say that, and I quote, "The specialists recognize the cultural values associated with the site as a flood plain," so in other words, the entire area, not just the rivers, "as the place of early confrontations between indigenous peoples and settlers. This significance, taken as a single complex of significance and symbolic meaning, is regarded by the HIA as being of the highest order in the current socio-political landscape. We submit that in those circumstances, the rights that are threatened with irreparable harm are not established prima facie. They are absolutely clear, lady. And that's on what's common cause in the discussion over the last 3 days. What is more, they are indeed, contrary to what the respondents would have you believe, they are indeed constitutional rights. This court is precluded with respect both by Section 39(2) and by the principle of subsidiarity from ignoring the fact that we are dealing with constitutional rights simply because they were not expressly referred to in the founding affidavit. The rights are rights to culture in Section 30 and 31, and the related rights to equality, dignity, and a sustainably managed environment. And the importance of Section 39(2)(b is that the court is, with respect, obliged to interpret a statutory provision having regard to the spirit, purport, and objects of the Bill of Rights. So even if one relies simply on a statutory provision, particularly one which is there to provide an element of one's cultural rights, automatically the Constitution requires the court to engage the Constitution. So there can be no suggestion that we haven't established a clear right that is threatened with irreparable harm, and that that clear right is made up of a number of constitutional rights. As was correctly pointed out in the Shell case, in interim interdict proceedings, the fact that constitutional rights are at stake weighs heavily in the applicant's favour. It's also acknowledged in various of the respondents' HIA reports that heritage resources will be negatively impacted. For example, at page 171 in the July 2019 version of the Heritage Impact Assessment, the consultant said, and I quote, "The greatest negative impact of both the preferred riverine corridor and island alternatives on the floodplain as a whole and the site and surrounds is that the proposed development will result in a fundamental change in the appearance and character of the site, which has been perceived as a negative impact by almost all commentators." Coming from the respondent's heritage expert. How then can it be suggested that the intangible heritage that one associates with an associative cultural landscape is not permanently harmed by the transformation of that very landscape from an open green space to one with massive buildings reaching in various instances to 10 stories, plus the raising of the underlying land? So we say whatever your interpretation of OTA, we're easily home and dry on OTA. Before moving away from OTA, the second basis upon which it is distinguishable is that they were there, the parties who successfully got the interdict in the High Court were attempting to interdict government itself. It was the target of the interdict from implementing decisions pertaining to the establishment of toll roads. That meant that there were very serious separation of powers concerns that were raised. And the judgment has several warnings about how carefully the courts need to tread in that situation where you're directly interdicting the government. We aren't interdicting the government in these proceedings. We're simply interdicting the developer, a private party. So we really sit under the traditional law, as it were, in relation to interim
Can you pause
interdicts.
for a moment? What is the current position with regard to the review proceedings?
With
from
regard
the
to that?
perspective of the applicants?
I'm afraid I didn't hear you. You said, what is the current position in regard to that?
The review proceedings from the applicant's perspective.
Well, as far as the review proceedings are concerned, lady, as I understand it, we now await the provision by the authorities of the Rule 53 record. As soon as that record is provided, we can respond. My sense, although I haven't explored it, is that the record must be several weeks, possibly we're into months late, because I think there's a 10 or 15-day time limit in Rule 53 as to the provision of the record. So that's where we stand. As soon as the record is provided, we can get on with preparing the supplementary affidavit. And, lady, let me make absolutely clear, my instructions are to tender full cooperation in ensuring the speediest review proceedings. My learned friend would have you believe that it's an inevitable story of delay. We have more faith in a judicially managed, if necessary, case management process, which could ensure that this gets there fast. A lot of the necessary water has already flowed under the bridge. Most of, if not all of the important documents are in fact already part of the pleaded case. There is no reason why one shouldn't quickly get into a position where it's time for further affidavits to be filed by the respondents. And let's think about it. They've put up very substantial affidavits already justifying those decisions. There must be a limit on how much more they have to say about it. So we don't see it a 12 to 24 month inevitable delay. And as I say, we tender full cooperation as far as a speedy review is concerned. And coming back to the tests on prima facie, the other case that was referred to by the first respondent is the South African Informal Traders case. It was decided subsequent to OTA and confirms that there is no intention to introduce any variation in the legal regime pertaining to interim interdicts. Whereas the Constitutional Court confirmed that, and I quote, a prima facie right may be established by demonstrating prospects of success in the review. And it refers to the 1973 judgment of the Appellate Division in Ericsson Motors. So our submission, lady, is that the law has not changed. But even if it has, on the first respondent's interpretation of OTA, the requirement of demonstrating irreparable harm to a prima facie right is more than adequately demonstrated on the common cause facts and on the respondent's documentation to which I've referred, Your Ladyship. It's also significant, the first respondent refers to cases such as Beck's case, which confirm the principle that if the review is shown in the interim interdict proceedings to be based on a particularly strongly established review ground at this stage, then the approach is the sooner the building is stopped, the better. And we submit that that is precisely the position in this case. Milady, to come back to an aspect of the discussion around the interpretation of the statute, much of the debate has focused on what the implications were of the Interim Assessment Committee failing to attend a workshop and a meeting, and Heritage Western Cape's not having responded differently to the correspondence from the minister. They responded, but the complaint is that they should have responded in a more forthcoming fashion. Our submission generally is that if objectively assessed, the requirements of Heritage Western Cape in their letters of 13 September 2019 and 13 February 2020 were in fact clear and objectively assessed, the heritage practitioners did not respond to those requirements. A subsequent unanswered request for clarity, where clarity already existed on the record, cannot retrospectively undo what took place on record and under the statute. Moreover, if the record shows that such clarity already existed, then there is a limit on the criticism that can be directed at Heritage Western Cape for simply referring back to the clear documents when the minister corresponded with them. Nevertheless, even if the court is against us on those submissions and were to hold that the letters of 13th of September 2019 and 13th February 2020 must be totally ignored as a result of Heritage Western Cape's conduct, and we submit that would be a difficult thing to justify with reference to the clear compulsory terms of the peremptory terms of the statute. We submit that in any event, the statute imposes information requirements in and of itself, regardless of what Heritage Western Cape may or may not require, and regardless of what they may or may not subsequently do in relation to the minister's subsequent decision-making process. So just for purposes of refreshing our memories, if we can just have a look at the opening part of section 38.3. It says the responsible Heritage Resources Authority must specify the information to be provided in a report required in terms of subsection 2A, provided that the following must be included. So even if one had a situation where they were completely supine, they did nothing, Heritage Western Cape, in terms of specifying the information requirements, the statute would kick in and would require compliance with every one of A to G. On that basis, we submit that there is still really no answer to the flaws that we have identified in our main argument, particularly in relation to the supplement at pages 30 to 39 of the notes for oral argument. Those haven't really been addressed, and save in the limited respects I'll refer to, we stand by what is said there.
How would those flaws have impacted on the minister's decision?
The flaws would have impacted on the minister's decision because if one looks at the proviso in section 38A, it is peremptory that they have to satisfy the requirements of section 38.3. There's no way out of that, number one. It isn't to the extent that the director or the minister considers necessary. It doesn't say to the extent, such as is in the opinion of the director or the minister necessary. Those subjective kinds of wording that signify an element of discretion are simply not there. So what the decision maker, director or minister, has to do is before they get going with any decision-making processes, first see that section 38.3 is complied with.
So what type of information would have impacted on the minister's decision that was not provided?
If I can then come to that. So I've already made a reference to, and for the purposes of saving time, I don't want to go through it again, but I went in quite a lot of detail through the supplement, and the notes that we handed up deal with what we say in relation to each and every one of the sections of the supplement. We go right through to right through to I think to section 6 or something like that. We work through the various sections. I'm not sure if your ladyship would like me to go there again. It wasn't seriously taken up by any of the respondents.
Look, it's common cause that the property is of great historic and cultural significance, has both elements of tangible and intangible heritage resource value. What additional information could have prompted the minister to refuse environmental approval? Even if you give the highest level of cultural and historic significance, the highest level of tangible and intangible heritage value significance, how would that have impacted on the decision made by the minister?
Well, the first submission I'd make in that is that, in fact, on a reading of the statute, it doesn't matter. It simply has to be done. However we might here in court
Can you
view
just
it.
remind the court what was not done?
Well, if I can,
I'm looking at, I have your notes here in front of me. Can you just indicate
So-
it? You said that you
yes, so I'm going
highlighted
to deal,
it.
I'm going to deal with
What
some
was not done?
so there are two things. The one is, and let me give your ladyship the reference.
Look, the fact that Mr. Ahrens's qualifications and methodology were criticized, the fact that his conduct or his impartiality may also have been questionable. The court noted the concerns raised by the second applicant.
That's part of it, lady.
Yes,
So just
but
to,
how does it assist the minister to arrive at a different conclusion? The fact that Mr. Ahrens didn't follow the correct methodology or whatever criticisms they have. So remove Mr. Ahrens from the equation and explain to the court, besides criticism of Mr. Ahrens' methodology, etc., what is the nature of that information that was lacking that could have prompted the minister to refuse this application?
can I take you initially through it? I can do it paragraph by paragraph. And
Where
then
will you take me to?
if you're not here in my argument, and if your ladyship wishes me to, then we can move on to the comments in the original notes on the supplement. But if I can start with paragraph 38.3a. 38.3a says there must be both identification and mapping of all heritage resources. The paragraph requires two distinct processes, identification and mapping.
Did
means
mapping
what?
not take place at all? Or was the mapping insufficient? Or was insufficient weight attached to the mapping? What is the position?
There was a serious shortfall in the mapping itself, and I'll take your ladyship now.
So there was a shortfall.
I'll take your ladyship now to the maps, so we can see where the shortfall lies. So we said that there must be a map that shows all of them. It must be prepared by the heritage assessment practitioners. No such map has been drawn to the court's attention in any of the 3 days that we've been arguing
Is there
about
anything
this case.
that would be included in that map that is not on record at this stage?
I beg your pardon?
Is there anything in the mapping process that
That's not on
should
record.
have been included that is not that does not form part of the record?
Not.
We have an idea of what we are dealing with, isn't it?
I don't think there's anything other than it's 5 diagrams that I will refer your ladyship to. And
So the diagrams, what's the word that you use? It's
I
insufficient.
said diagrams. I mean maps. So let's assume in favour of the consultants that these were maps, and if we can start at page 2518. And we're looking now at the July 2019 Heritage Impact Assessment. I think it's volume 5, lady.
2518.
2518.
Yes, I'm with you.
And we see on that page what is described, in fact, as a diagram,
Yes.
figure 31. And what we have helpfully there is a dotted line showing where the development is. And your ladyship will see that it's completely empty. And then at the bottom it says, diagram of current significances of the riverine topography as cultural landscape. It's very difficult to understand what is being spoken about, but one thing's for sure, there's no mapping of heritage resources, tangible or intangible, on that diagram. Then, if we turn the page to page 2518, I beg your pardon, 2519, we see figure 32. It's again got a dotted line indicating where the development is, and there's a bit of black shading now that comes into the development area, presumably referring to the envisaged water. I imagine of the rehabilitated canal is my guess. And it says, diagram of future significances of the riverine topography as cultural landscape after restoration of the Lesbiac River. So again, there's no attempt at all.
What would the purpose of mapping be?
The purpose of mapping would be to see what tangible and intangible heritage is there and what it is associated with. And the fact of the matter is that the legislature has decided that that's an important exercise to engage in. And it would seem to me that a visual depiction would make sense in these circumstances. It would assist.
How would a visual depiction impact on a decision? We know where the rivers are located. We know where the position of the mountain, Signal Hill, or whatever. We all know what we're dealing with. And I'm just interrogating this aspect of mapping to see what is it about the existing maps that is lacking, because intangible heritage resources is an abstract term. It's an abstract term. An intangible heritage resource. It's not, you cannot necessarily draw it. You cannot draw a poetry session or a ritual that took place. You cannot draw it next to the river. I'm just making an example now, just giving examples.
Lady, it's an associative cultural landscape, and there would be different parts of the landscape that would have different associations and meanings. And it would force the heritage impact assessors to explore those meanings and to explore how they interlink with the different parts of the site. And so, for example, lady, perhaps if there had been a proper consideration to mapping the green open space in the middle and working out, for purposes of the mapping, going through the mental process of working out what the association was with a particular form of intangible heritage and exploring that with the communities involved, it may very well have been a helpful process to go through and might have assisted
And assuming
them.
the mapping was done completely as envisaged by the applicants, what does the applicants predict would have happened? Would there not have been approval for this project? Is it as serious as that? This shortcoming with regard to mapping. Would it materially have impacted on the decisions made with regard to the River Club project?
We submit very likely yes, if it had been done in an objective, independent, impartial manner that weighed each of the impact, each of the resources, their significance, the impact of the development on each one, and a weighing of the impact against the socio-economic considerations, it may very well have led to a different decision. But, and I'll come to it, part of the difficulty here is this was always going one way. So if your ladyship's conclusion is, given these facts as it was only going one way, yes, we agree with you, lady. This was only going one way, and that was towards approval, and it didn't make a difference what you did because of that initial, not even binary indication of lack of alternatives came right in the preface to the 2019 Heritage Impact Assessment, and we see the same attitude prevailing at the end of the supplement. So we agree with you, lady. Yes, with these assessors it was going one way, but done properly, it may very well be that a minister who had a good consciousness of culture and intangible heritage would have said, gee, this place is special in South Africa's history. This place is a place that can bring about reconciliation that our country so desperately needs. This place, if we think about First Nation peoples, is one of the few remaining places where they can evoke their intangible heritage. And he might say, yeah, I think maybe this is something where we've got to look at it differently, look at a different vision for this land.
So there's a possibility that the minister could have imposed different conditions. Or there was a possibility that the whole project could have been rejected.
Could have been rejected, lady. Could have been rejected. Could
So
have been
assuming the court is with the applicant and the court is of the view that had some of the insufficient details been provided, it's possible that the minister could even have refused to approve the project, be it just environmental or both land use and environmental. What is it that the applicant wants? What must happen?
Sorry, what must happen?
To the property. Assuming the court is with the applicant and the minister would possibly have been with the applicant and imposed different conditions or reject the approval, reject the application for environmental approval or land use approval. What is it that the applicant wants?
Well, one saw in that list what looked like their ideal possibility was, which was that it becomes an international heritage site. That's how importantly they assess that particular land.
But were those processes triggered by the applicant or accessed by the applicant?
Well, those processes don't, as far as I read the National Heritage Resources Act, don't enable a private person to apply, for example, for a heritage to be created. They don't own the land.
But I don't think that it's sufficient to make that statement.
But
Are you saying the onus is just on the state to decide what is going to be a heritage site or not? We have very, very vocal civil society groups who can take action, or any individual person can take it upon them to promote the declaration of a site as a heritage site, albeit national, local, national, it doesn't matter, international. Are you saying that it is in the state's hands as to whether an area will be declared an international, a heritage site?
My understanding, and I hear your ladyship, my understanding is that they did indeed act in that way, and I think it's exemplified what happened with the earlier TRUP process. I think they were involved in that in a very vibrant way.
Suburban park proposal.
And I think that was one of the things that was considered in the earlier TRUP process.
Is that what the applicants want?
No, as I've indicated, I think their ideal would be a World Heritage Site, but certainly it's got to be something that remains of the status of open land.
When did the applicants decide to? I will use the word. I'm using the word cautiously. When did the applicants make the decision that this area needs protection to the extent that it should even be given World Heritage status? And I'm asking this question in the context of a golf course. You have a golf course at the River Club. Did the applicants do anything to promote or this land, the pocket of land, to be declared a heritage site?
I've mentioned the one. I mean, they had, I think part of their submissions, they specifically said that their vision was in the one that was referred to, I think by counsel for the eighth respondent, one saw there the reference to this particular vision. But
The fact that you have a vision does not mean anything. You must take decisive action. This is your heritage. You want it to be preserved and protected. I'm trying to establish that the first and second applicants have no problem while the property was used as a golf course. There was no problem with that. Is that the position?
My recollection of reading of the record doesn't enable me to respond as to whether I can find something on the record, and I can ask that be checked, and if necessary, I can also ask if there is something that isn't on the record, as far as that is concerned. I don't know how far back it goes, but one must remember, with respect, as your ladyship pointed out, its history is very much tied up with its colonial past, culminating. I mean, certainly, I don't think any of my clients would have been welcome at the South African Railways Recreation Club during the times that it was being converted for that particular use, and even less so before then.